Good afternoon, Sandra. Can you hear me?
Yes, I can.
Hi, how are you?
I'm good. How are you?
I'm good, thank you. I just made you co-host, so there are a few defendants here. So if you just want to grab them and take them in a breakout room, that would be great.
Perfect. I'll start doing that. Thank you so much.
Okay, thank you. person who is identified as LG Stylo, can you hear me?
Oh, good morning, Dad. Welcome.
Ma'am, who is identified as Samsung, can you hear me?
Turn that off.
What is your name, please?
Is that me?
Yeah, yes, yep, you.
Vanessa Etherton, can you turn the TV on, please?
Thank you.
Mhm. Mhm.
Oh, gosh. Oh, I saw they were back. Mm. Who, me? He doesn't know. Maybe that'll change. Maybe that'll change. I think it'd be beneficial. I know.
Because right now he's just figuring it out.
I'll see you later. Good afternoon. Today is Tuesday, January 3rd, 2023. I am Judge Martin. This afternoon's docket is landlord tenant only. If you do not have a landlord tenant matter, you are most likely in the wrong courtroom. You should double check your notice. If you're not sure where you're supposed to be, please feel free to send a chat to our staff and they'll help you get where you need to be. Marianne, is there anything ready?
No, ma'am. There's an attorney from Palett's Law that's in a breakout room. There are several of their defendants that are here, but that's it. Oh,
Thank you.
yep, you're welcome.
Mr. Katz, you've been made a co-host. If you see tenants from your, on your cases, if you want to move them into breakout rooms and discuss the cases
Okay,
with them. I see
I think
somebody
I've
else
only
here
got
from your
one
office.
case. Is that correct?
Barrington versus Shelby.
I think that's it, correct?
How is that possible? Yes, sir, that is it.
How is it possible? It's a stay case.
All of these afternoons cases are stay cases.
Yeah, so I only had one, I guess, with you at least. So,
Oh,
all right,
lucky me.
I will look out for them, and if I see them here, I will jump into a breakout room with them. Thank
If
you.
they're not here by 1:15, I'll get your case called, get you on your way.
Okay, perfect. Thank you, Your Honor. Happy New
You're
Year.
welcome. Happy New Year, sir. Miss Lacy, have you been in communication with Mr. Levine's office?
Not today on this matter. I did, in your honor, I was talking to the client yesterday. She got a notice for tomorrow. She is zooming in, but maybe Mr. Levine's office, only got a notice for tomorrow also. I'm not sure.
No, they just joined.
Oh, I see
Somebody
them.
just came in. Ms.
Okay.
Hart.
And then, Miss Thomas should be zooming in now. I just gave her the right information.
Okay.
If your honor would like to put me in a breakout room with, Miss Hart, that'd be great.
Absolutely. Marianne will get you into a breakout.
Thank you.
You're welcome.
Okay, what about now? Can you hear me okay?
Oh, my goodness. Yep, I see what happened. Unbelievable. Marianne.
What happened? Okay.
Oh.
Two. Turn that off.
Sir, who was just speaking, can you hear me?
Yes,
What is your name, please?
Christopher Moss.
Thank you. Miss Cozy, what happened to Ashley? But you're muted.
We had entered into an agreement.
Absolutely not, unless it's on the record.
Yeah, I don't see her.
Okay, I will go ahead and contact her and let her know to get back on the line.
What was the agreement that you reached with her?
I'm sorry, we had entered into consent judgment. I believe I thought that we could enter into an agreement with a breakout room, but that was my mistake. I will go ahead and give her a call right now.
Thank you. Because we have questions. We want to know what happened with the Sarah application. We
Yep,
wanna
I will
know,
get
was
on the
there any
line.
dispute? Thank you. No. Mr. Katz, are you available?
Yep.
2240303 LT. This is Barrington versus Shelby. May I have your appearance, sir?
Good afternoon, Your Honor. Sidney Katz on behalf of the plaintiff.
Today is the day and time set for hearing on plaintiff's request to lift the Sarah stay. The case was scheduled for 1 o'clock. It's 1:13 by the court's clock. Is Jabri Shelby here? There's no response to that name, Mr. Katz. There's no one by that name in the breakout. There's no unidentified persons in this court's waiting. How would you like to proceed, sir?
Your Honor, at this time, requesting a default judgment. This is a non-payment rent possession case. Currently, there's a balance due of $3,497 of past due rent, $165 of costs, for a total of $3,662. Requesting a default judgment in that amount with the writ to be issued after January 13th.
Thank you, sir. Defendant, having failed to appear, default judgment shall enter in favor of plaintiff and against defendant with rent to retain possession of $3,497, $165 in costs for a total judgment of $3,662. Plaintiff's office will submit that judgment for entry. Anything else this afternoon, Mr. Katz?
That is it, Your Honor. Thank you.
Thank you, sir. Have a good
Have a
day.
good day.
Ms. Lacy, did you need to speak to your client?
If I could get a quick breakout room with my client so that I can update her.
Absolutely. We'll get you moved in with Ms. Thompson.
Thank you.
Ms. Cozy? This is 223382 LT. This is Park Estates versus Donald White.
Good afternoon, Your Honor. Sumption Hart, P69542 on behalf of Park Estates.
Good afternoon, Ms. Hart. Today is the day and time set for a hearing on plaintiff's request to lift the SARA stay. That stay has been in place for 111 days. This case was scheduled at 1 o'clock. It's now 1:15 by the court's clock. Donald White. Hearing no response, how would you like to proceed, ma'am?
Your Honor, would ask for a default judgment to enter against Mr. Wright for his failure to appear. Rent to retain possession in this matter of $3,217.37. Court cost amount of $153.57 for a total redemptive amount of $3,370.94. And we're to issue after January 13th, please.
Thank you. Defendant having failed to appear as directed by this court, default judgment shall enter in favor of plaintiff and against defendant with total judgment $3,370.94. 10 days to pay or move plaintiff's office to submit that judgment for entry. Anything else in this matter, Ms. Hart?
Nothing additional, Your Honor. Thank you.
Thank you. (224486 LT). This is Trilogy Residences versus Jason Raby.
Sumption Hart on behalf of Trilogy Residences.
Today is the day and time set for hearing on plaintiff's request to lift the SARA stay. That stay has been in place for 83 days. Jason, oh, here he is. Ms. Hart,
Yes.
have you spoken to Mr. Raby?
No, Your Honor, I didn't see him on the screen.
Would you do me a favor? Looks like you have been made co-host. Would you take Mr. Raby into a breakout room, speak with him, please?
Absolutely, Your Honor.
Thank you. Oh. This is 224536 LT. This is Beal Properties versus Dewa and Durgos.
Oh, Your Honor, I'm sorry. Beal Properties is also one of mine, and I'm trying to move Mr. Raby into a room.
Thank you.
You're welcome.
If you see invitations from the attorneys to go into breakout rooms, please go there with them. Once you finish your discussions, come back to this main session and we'll get your cases called. This is 224235 LT. This is Enmark versus Moss and Moss.
Oh, you're asking, oh. Sandra Kuzi on behalf of plaintiff.
State your name for me, please, sir.
Moss, Christopher Moss.
Where's Lakita Moss, sir?
She's here.
Here I am. Hi,
Hi, state your name for me, ma'am.
I'm Lakita Moss.
Thank you. Today's the day and time set for hearing on plaintiff's request to lift the SARA stay that's been in place now for 90 days. Have you received funding from your, for financial assistance with the past due rent?
No.
No,
What's the
we
status
we
of your
haven't been able to
application?
get in contact with anybody there over the holiday season.
Your application's been pending for 90 days. You've not had any communication from anyone in 90 days?
Give me just a second. What is this?
That's a month right now.
Ms. Sozi?
Hold on, show me that again.
Um,
Hey, let you close it.
Oh, so this is.
Ma'am, has your client received payment of the past due rent in this matter?
No, Your Honor, they have not received any payment.
What's the rent to retain possession?
It says,
No, sir, I'm asking the attorney.
oh, okay.
The rent to retain is $6,830 for a cost of $198 for a total amount of $7,028.
Mr. Moss, you were starting to say.
What day was this?
That's the 10th, and they said that.
I mean, it says, the application has been approved. However, we haven't heard anything else additionally.
The application was approved when, sir?
10/17/2022.
Have you followed up since then?
Yes. We haven't been able to speak with anybody. We've called, we left emails. I'm not sure what's going on with it.
Did you hear the attorney indicate that $6,830 in rent is due and owing?
Yes,
Is that an accurate amount?
I just don't know. This is not- it was she said 7,000.
yeah, she said 7,000 at the time.
That was
When? Just
after,
now?
that was after the cost. My question is $6,830 in rent due and owing?
Yes.
Yes,
Inasmuch as you admit and acknowledge that the rent due and owing claimed by a plaintiff is accurate, there remains no tribal issue. And plaintiff is entitled to entry of judgment as prayed, that being $6,830. They're also entitled to $198 in court costs. That's a total judgment of $7,028. The Sarah stay is lifted inasmuch as more than 30 days have passed and they have not received payment. Ms. Solzy, is your office prepared to submit a judgment with those amounts?
Yes, Your Honor, I'll submit it after the court
Thank you.
hearing.
Mr. Moss, once you receive a copy of the judgment, I would suggest that you forward it to the agency that you made your Sarah application to and let them know the judgment is now entered. Maybe that will expedite their processing of your application and forwarding of payment to your landlord.
okay.
Anything
Yes.
else on behalf of plaintiff?
Nope, Your Honor, that's all.
Is there anything
Anything
else I
else?
need to know?
Anything else? The plaintiff's office will submit a judgment. This court will sign it and copies will be mailed to you at the address we have on file.
Okay. Okay,
Thank you.
All right.
All right.
Thank you.
This is 224486 LT Trilogy versus Rabi. I have your appearances. How are we proceeding this afternoon?
Is that for me or
Ms.
the?
Hart?
Okay.
You're muted, ma'am.
I apologize, Your Honor. Mr. Raggy and I have come to consent judgment, Your Honor. I did advise him of his rights under 4.201. Rent to retain possession, $7,200.88. Court cost the amount of $164.57 for a total redemptive amount of $7,365.45, written to issue after January 13th.
Thank you. Mr. Rabi, what happened with your application for rental assistance?
I was denied, and then when I went back on to resubmit my information, it said the portal was closed.
Thank you, sir. You heard the attorney indicate that there'll be a consent judgment in this case for
Yes, ma'am.
$7,200.88 in rent
Yes,
and $164.57 in court costs.
yes, ma'am.
And that's the judgment that you wish to enter, sir?
Yes, because I mean, at this point, there's nothing I can do if my application's been denied, correct?
Because your application's been denied and the plaintiff has
Mhm.
requested the Sarah stay to be lifted, the court will lift that stay. And as much as you agreed to enter the consent judgment for a total of $7,365.45, the court will enter that once it's been presented. Because you appear by Zoom, there's not a signed consent judgment. Have you authorized the attorney to sign the judgment on your behalf?
Yes, ma'am.
Because the plaintiff is represented by an attorney and you are not represented, that judgment will not be enforceable for 3 days. Understood.
Okay.
Anything else on behalf of the plaintiff?
Nothing additional, Your Honor. Thank you.
Any questions, sir?
Yes, just one. You said that won't go into for like it won't go forward until 3 days. So just explain that to me as far as since I'm not there, like the consensual, the signature.
The best way to explain it is once you receive the
Mhm.
judgment, if it doesn't match what you say it did, you can ask the court for an additional hearing in the matter.
Okay. Yes, ma'am.
Anything else, sir?
No, that's it.
Thank you, sir. Have a good day.
You as well.
Thank you. Ms. Lacy, are we ready with Ms. Thompson? Ms. Lacy?
I'm here, Your Honor.
This is 223387 LT. This is Park Estates versus Thompson. May I have your appearances, please?
Gabriel Lacy on behalf of Ms. Thompson, Your Honor.
Assumption Hart on behalf of Park Estates, Your Honor.
And thank you. Ms. Lacy, the court did have an opportunity to review the court's ROA, and there is a case scheduled tomorrow with these same parties. That case number is 226127. This court has some concerns that plaintiff would file a new case while there was a Sarah stay pending in this case.
So I noticed the 2 court dates when I spoke to the client over the holiday break. There was a Sarah stay. She did receive Sarah funds, but that has dried up for her. She does not have a pending application, and she is not waiting for any further funds.
As for the case that's before this court this afternoon, how are we proceeding?
Your Honor, Ms. Lacy and I have come to consent judgment on this matter. Ms. Thompson's rent to retain possession is $10,286.91. Court cost amount of $153.57 for a total of $10,440.48 for it to issue after the 13th. And Ms. Lacy gave me permission to sign her name on the consent judgment.
I'm sorry, give me that total again, ma'am.
Yes, $10,440.48 would be the total.
Thank you. And Ms. Lacy, that will be by consent judgment?
That is, she has 10 days to, it is our understanding she has 10 days to move out and or show proof of employment at the rental office and a substantial payment plan.
Thank you. And I raised the issue of the 226127 case, the non-payment case. That would, looks like it would be December rent. Is December rent included in today's judgment?
Yes, Your Honor, it is.
So the 226127 case will be dismissed?
Correct.
I'm asking that that case be dismissed or motioning for that.
That case is actually, looks like it's its first hearing tomorrow, so plaintiff's office will get that sent over. And I'm thinking that the filing fees and the service fees will not be assessed to the defendant as much as that case should not have been filed. That's an aside more than anything else. Anything else on behalf of the plaintiff in this case?
No, Your Honor, thank you.
Anything else on behalf of the defendant?
No, Your Honor, thank you.
Thank you. Ms. Thompson, good luck to you, ma'am. Have a good day.
Thank you, you as well.
Thank you. Are we ready on 224536 LT Bill versus Dewa and Burgos?
Yes, Your Honor, we're ready.
Sir, would you unmute yourself, state your name for the record, please? Thank you. And where is?
It's slowing down a second. It's Cameron Dewey.
Thank you. Where is Genevieve Burgos?
She's not here right now. Does she have to appear as well for this?
she should, otherwise she'll be deemed in default. It's okay.
Okay, one
I mean,
moment.
People do it all. the-
She's
No,
like, she's
no, no, not-
here, but
Not
She's-
one moment for a 1 o'clock case is being called at 1:29. Today is the day and time set for
Sorry.
hearing on plans for, no worries. Plans requested list of Sarah State has been in place for 83 days. How are we proceeding this afternoon?
Your Honor, we'd ask for judgment to enter. Rent to retain possession would be $1,445.52. Court costs in the amount of $199.14 for a total of $1,644.66. We'd ask the writ to issue after January 13th, Your Honor.
Sir, you had the opportunity to speak to the attorney. Do you admit and acknowledge that $1,445.52 in writ is due and owing?
yes.
Sir, what's the status of your Sarah application?
It's been denied. One moment. It said that my income had been too high. I had Genevieve do a application for ERAP, and they were able to pay, I think, let me see here, 2 payments of $800. It went from like 5,000 something down to like 4,400. I
Sir,
could
you're-
pay it like half. Go ahead.
I was gonna say you're breaking up. I'm not sure what's causing your voice to be distorted, but I heard the part that ERAP is paid partial. Inasmuch as you admit and acknowledge that the amount of rent claim due and owing by the plaintiff's attorney is accurate, there remains no tribal issue effect. Additionally, you've admitted that the Sarah application was denied. The Sarah stay will be lifted. Judgment will enter in favor of plaintiff and against defendant with a total due of $1,644.66. Plaintiff's office will submit that judgment by email to the court for entry. Anything else in this matter for the plaintiff?
Nothing additional, Your Honor. Thank you.
Anything else, Mr. Dewa?
I'm kind of new to this whole thing. If I if I have a written thing, sorry, and I never did win the court.
Sir, sir, you don't have a
Is
good
there any
connection.
way
I'm
I-
only hearing about. You don't have a good connection, so I'm only hearing about every third word.
Okay, yeah, yes. I've tried
Sir.
I tried to email. I've been emailing my landlord about a payment plan. I haven't heard back from them yet. But yes, on
Sir.
December, I applied for. You had applied for ERAP on the since August, and we haven't heard it got anything back till December 15th, which was only about like, let's see here.
No, sir, no. Whatever you're doing is making it so I can't hear you. You're breaking
Okay,
up.
sorry.
No, so what, you had a question?
Yes. I'm not really keen on the language of this. So I get a judgment for $1,643.52. You said I have to pay it?
Sir? Your connection is patchy. If you would leave and try to come back in, I'll hold on to the file for a moment to answer your question, okay?
Okay.
Thank you. This is 22463 LT. This is Rawsonville Woods versus Tina Burns. May I have your appearances, please?
Stage Jacuzzi on behalf of plaintiff.
Okay, there we go.
State your
Sorry.
name, ma'am. Ma'am,
Yes. I'm trying.
State your name.
Tina Barnes.
Thank you. Today is the day and time set for hearing on plaintiff's request to lift the SARA stay that's been in place now for 76 days. Ma'am, what is the status of your SARA application?
It's still pending. It that they'd expedite it, but it's really hard to get a hold of anybody. They just say it's pending.
Ma'am, what is the rent due and owing to your client?
The rent to retain is $4,326, a cost of $164 for a total amount of $4,490.
Ms. Barnes, were you able to hear that just now?
Yeah, I didn't get how much was it? 4,000?
$4,326 due in rent.
I'm sorry,
Okay.
$4,490.60.
Wait, 4,490?
No, ma'am, no. Hold on 1 second. Is the past due rent $4,326?
Yes, it's 60 cents.
Yes, that was my,
Sorry, Your Honor.
no worries. That was my question to Ms. Barnes. Ms. Barnes, is that an accurate amount of rent that is due and owing?
Sounds like, yeah, probably.
Ma'am, here's the thing. The SARA stay is only supposed to be 30 days. The court gives 45 days. The
I know.
plaintiff may then ask the court to lift the SARA stay if payment hasn't been received or the application hasn't been denied. We're 76 days out. Plaintiff hasn't received
I know,
payment or notification that you've been denied. For that reason, the SARA stay will be lifted. And you've acknowledged that the amount of rent claim due and owing by the plaintiff's attorney is accurate. For that reason, there remains no tribal issue effect, and plaintiff's office may submit a judgment to this court with those dollar amounts, the $4,326.60 in rent, $164 in court costs, for a total judgment of $4,490.60.
Okay, so I don't know what they just said that, the first step, approved, and then waiting, it's pending on the second. I mean, it's hard to,
Ma'am, you were breaking up. They said what?
they said that, it was approved, and there's like steps they go. Now they're
Ma'am,
waiting.
it was approved in what?
The second step, they're waiting. Oh, it's pending now. That's what they told me.
I understand, but the issue is there's an administrative order that required this court to stay or stop the proceedings while your application was pending. We are beyond the time for the application to be processed, approved, and payment made to the plaintiff's attorney. For that reason, the court has to lift the stay and enter the judgment since you agree that the amount of rent claim due and owing is accurate. What will happen next is the plaintiff's office will submit a judgment to the court. The court will sign it, and a copy will be mailed to you at the address that we have on file. Once you get that judgment, the court will suggest that you send it, communicate it to the agency that you made your application to, and maybe that will expedite the processing of your application and the forwarding of funds to your landlord. In the interim, if you're able to make arrangements, I would suggest that you be in communication with your landlord versus nothing happening as another month of rent has come due now.
So I wait for a letter. I'm sorry. I wait for a letter to come. Is that what you're saying?
I'm saying a copy of the judgment will come to you. Plaintiff's office will email it over to the court. I'll sign it, and then a copy will be mailed out to you.
Okay. And then I sent
So
that
you
to,
should I'm saying whoever you made your application to, let them know that this is happening.
I
And
will.
maybe that will expedite. Okay. Anything else, ma'am?
No, so how many days do I have?
10 days, ma'am.
10 days to be paid?
Yes, ma'am. Yes, ma'am.
And we go back to court, or?
If you haven't paid or moved within that 10 days, the plaintiff's office may make an application to the court for an order of eviction.
Okay. Okay.
Anything else, Ms. Barnes?
Oh, I'll try to get hold of them. Thank you.
Thank you, ma'am. Good luck to you.
Yes, thank you.
Thank you. This is 222.
I'm sorry. Am
225. No. Were you asking something else?
I done?
Yes, ma'am, you're free to go.
All right, have a good day.
You too. 224536LT. We're back with Mr. Daywell. What was your question, sir? Sir, Mr. (224640) Rawsonville Woods versus Vanessa Etherton.
Hello, Your Honor, Sandra Kuzi on behalf of plaintiff. I just want to state that this matter was actually dismissed. Payment has been made in full.
Thank you. Ms. Etherton, did you hear that?
Yes, I did. I was just making sure.
Thank you. The court has not received the dismissal as of yet, but I'll note the file. Ms. Etherton, you're free to go. Good luck to you.
Thank you.
(224657) Rawsonville Woods versus Price.
Sandra Kuzi on behalf of plaintiff.
Ms. Price,
Yes, I'm here.
turn your video on. State your name for the record, ma'am.
I'm trying to now. I think I'm gonna have to go out and go back in. Oh wait, there you
Nope,
go.
nope, don't go out.
Champagne price.
Thank you. Today's the date time set for a hearing on plans request to lift the SARA stay that's been in place for 76 days now. Ms. Price, what's the status of your application for rental assistance?
My Sarah application was approved and my Wayne Metro application was approved.
Has payment been made to your landlord?
Sarah said that they sent the check out when I spoke to them a couple of days ago, and they said that Rawsonville Woods needs to contact them to say that they haven't received the check. And I reached out to Misty and I let her know that via email.
And the amount of the check?
I don't have an exact for the Sarah, but I know it's 3,000 something. And then I know the Wayne Metro was 7,700 something.
So $10,000 has been paid to your landlord?
Well, the Wayne Metro one, they haven't gotten yet but it has been approved as of December 20th. Okay. But the Sarah, they said they've been mailed that check out, but they say they didn't get it here yet. So they have to contact Sarah. That's what Sarah told me.
Ms. Causey?
Yep, Your Honor, at this moment, they still have not received funds from Sarah.
The rent to retain?
The rent to retain is $9,496.02 for a cost of $164 and a total amount of $9,660.02.
That's including January's rent. January's rent shouldn't be included in that.
Why shouldn't January's rent be included, ma'am?
Because it's not late yet. I have until the 5th before January's rent is late.
Rent is due on the 1st of the month, correct?
They give us a grace period up until the 5th before they add any late fees.
But rent is due on the 1st.
Yeah, I guess.
I'm asking you, I'm not telling you.
I was told I have until the 5th.
The 5th before late fees are added?
Yes.
Okay, but rent is due on the 1st of the month.
Okay.
No, I'm at Ms. Price. I don't know. I'm asking you. And if your position is that they shouldn't charge it, then the question would be, when is January's rent going to be paid?
January's
rent. 2
rent.
days.
January's rent is due on the 5th, so it'll be paid by the 5th. But they say they don't accept partial payments.
Rent is due on the 1st of the month. I hear what you're saying, ma'am, and it's included. It will be included in the judgment amount. Unless, are you disputing that there's $9,496 in rent due and owing?
Yes, I am.
You're disputing it?
Because I didn't know I was here for January's rent.
Once a non-payment of rent case has been filed, every month the rent that comes due while that case is pending gets added on the 1st of the month unless the lease sets forth a separate date. I understand your argument that it's not late until the 5th, but it's due on the 1st. It's like if your payday is on Friday, if your employer says, well, it's not late yet, and they pay you late, that's not acceptable to you. Rent's the same thing. Rent's due on the 1st. So let's put that argument on the side. And are you saying that as of today's date, that being January 3rd, 2023, is $9,496 in rent due and owing?
I guess, yeah.
The Sarah stay will be lifted. Plaintiff's office will submit a judgment with those dollar amounts in it, $9,496.02 in rent, $164 in court costs, for a total judgment of $9,660.02. Ms. Price, what I would suggest to you is that you follow up with the agency that mailed out the payment and the one that the payment is pending from. Let them know that judgment has been entered and that you'll have 10 days to pay or move from the property.
Okay, so as of today, I have a 10-day notice.
I'm sorry?
As of today, I have a 10-day notice to move.
Ma'am, this is a non-payment of rent case. So the total amount that I just placed on the record is what you will have to pay or move from the property within 10 days. That's just how judgments are. It's not a new notice. It's just entry of the judgment. What I'm suggesting to you and what I've suggested to other. Yes, ma'am.
What I'm asking is, do I have 10 days from today's date?
Yes, ma'am.
Okay, I'm gonna move within the 10 days.
Why wouldn't you just follow up with Sarah and Wayne Metro?
I followed up with Sarah. Sarah said Rossingville Woods have to contact them. I sent them the email and told them that. And I have my email proof that I sent it to Misty.
Ms. Price, what I'm suggesting to you is if these agencies are aware of the fact that you have now had a judgment entered, that might expedite the following up and processing of your paperwork. If you're saying to me that there's something that Rossingville Woods has to do to get payment, that's a different conversation.
Yes, that's what I'm saying, because Sarah said they mailed the check out.
I asked you when and what amount.
I can get you the amount in 1 second, if that's okay.
Absolutely.
Okay, Sarah was approved September 13th for the amount of $3,697. And Wayne Metro was approved for $7,741.51 on the 20th of December.
And ma'am, that's why I'm saying I am not suggesting any way, shape, or form that you move from the property when two agencies have committed to paying $11,000 in past due rent for you. What I'm suggesting is that you follow up with them to find out what happened with the first check. And if you were approved for $7,700 on December 20th, we're just on January 3rd. Those are phone calls and emails worth making versus trying to find some place to move right now.
Yeah, I spoke with both agencies.
Because
Wayne Metro said it can take up to 8 to 10 weeks. There's nothing they can do about it. And they also sent that same notice of approval to Rossingville Woods.
what will happen, ma'am, is if we get to 10 days from today and that September check hasn't been located in the, strike that. The judgment will indicate that there will be no writ without a hearing in this matter because of the fact that there has been an approval from one place and a check submitted from another place. Ms. Price, please follow up with the agencies. I heard what you said about the 8 to 10 weeks, but 8 to 10 weeks seems like an awful long time for an agency that 2 weeks ago committed to making payment, okay?
Okay.
Anything else?
No.
Ms. Price, unless you have anything else, you're free to go, ma'am.
Okay, bye.
Thank you. Mr. Daywell.
Okay, can you hear me now?
I can hear you. What's your question, sir?
Okay, you said I have till the 13th to pay?
Yes, sir.
Okay, well, that's the 13th period. Because I could pay half of it by the 6th, but I get paid bi-weekly now. I could literally zero out the balance by the 20th.
Sir, the court doesn't get involved in the payment plans and non-payment of rent cases. Follow up with your landlord's office. You would make payment arrangements through them and with them.
Okay, and I'm able to do that within those before the 13th, correct?
Yes, sir.
Okay, I've been making calls with them like the past couple weeks or so, and they haven't been answering or answering my messages or my emails. But I'm gonna keep giving it a try.
Is there somebody at the property? Like, is the property management office open?
No, they're not at the office at the property. They're remote. They work through in Ypsilanti. Because I've been telling them I can make the arrangements for it because they accepted the how much was the 3,600 from ERAP on December 15th, and they haven't they said that's all right, and they haven't emailed me after that after they received the payment, because ERAP was supposed to had pay we applied for ERAP over in August, and they haven't given us any payment whatsoever until around December 14th or 15th, and it's like
respectfully. Sir, this is just so the record's clear. This is 2245360T. The judgment that will enter will be for $1,644.66. If you're unable to reach your landlord about making a payment, the court will be interested to hear that. I would be shocked if a property owner was not accepting payments for some reason.
Okay. Thank you.
Anything else, sir?
That'll be all.
Have a good day.
All right, you too.
Thank you. This is 2244803LT. This is Huron Estates versus Morris and Shively.
Good afternoon, Your Honor. Sumter Hart on behalf of Huron Estates.
Ma'am, state your name for me, please.
Christina Morris.
And where is Robbie Shively?
I'm not here. Yeah.
Thank you. Today's the day and time set for a hearing on plans requested with the Sarah Estate has been in place now for 76 days. Ms. Morris, what's the status of your application for rental assistance?
I went through the Wayne Metro, the Wayne one. Sarah. Yeah. I called before Christmas. They said that it was in review still to call back after the holiday for updates on it, but I worked yesterday, so I haven't been able to call yet today.
Thank you. Ms. Hart, I'm sorry.
Yes, that's me, Your Honor.
I had to look back at the beginning. What's the rent due and owing to your client?
$3,463.20. Court cost the amount of $199.14 for a total of $3,662.34.
Ms. Morris, is that amount of rent due and accurate?
Yes, ma'am.
There was an administrative order that required this court to stay these proceedings for 30 days. We are past those 30 days and plaintiff has not received payment in full. Ms. Morris, in as much as you admit and acknowledge that the amount of rent claim due and owing by the plaintiff is accurate, there remains no tribal issue of fact, and plaintiff is entitled to entry of judgment in that amount. Ms. Hart's office will submit that judgment to the court. I'll sign it and a copy will be mailed to you at the address that appears in the court file. My suggestion would be that you follow up with the agency that you made the application with, advise them that judgment has entered.
Mm-hmm.
And maybe that will help to expedite the processing of your application.
Yes, ma'am.
Anything else, Ms. Morris?
I do know that they did ask me not to make any payments until I heard back from them, so.
Yeah, because we had money
who?
orders in the
Huron.
office.
No. Only one of you can talk because I can't hear you both at the same time.
Huron
Who told you not to
Estates.
make payments?
They asked me not to make any payments until I had heard back from the assistant program.
Your landlord would not take payment from you because your application was pending? Is that what you're saying?
Yes.
We have money orders.
Mr.
I have
need you to
I have
respond.
money orders proving that I tried to pay them from September.
Well, at this time, we are requiring payment. We wanted to see if you were able to get
So
authorization.
when I say the court doesn't need you to respond. Ms. Morris, what happens is because there was a stay pending and it was possible that the agency made payment in full, I'm sure your landlord just didn't want to muddy up the waters. But Mr. Cost has started to interject and say that now payment will be due. Ms. Hart's office will submit the judgment. The judgment total will be $3,662.34. You now have heard Mr. Cost say that now payment is due. So take those money orders and submit them to your landlord for application against your outstanding balance. That doesn't mean that you abandon your application for rental assistance. It just means you have a belt and suspender thing where payment will be
Now, I
made
will
either
say I
by
don't
you or
have
the
the full
agency.
amount because I was out because I had baby. So I was out for 6 weeks and things along that line. I have at least half of that right now.
I appreciate that. You heard me indicate in the other file that the court does not get involved in
ma'am.
payment plans and non-payment cases, but make payment to your landlord. I'm sure if you have an arrangement, they'll go beyond the 10 days as long as you can stay on top of it. Anything
Yes,
else,
ma'am.
Ms. Morris?
No, ma'am. I think that's
Anything from Ms. Shively?
that will be it. No.
Thank you.
Thank you.
Have a good afternoon.
You as well.
Okay.
Thank you. 223695 LT Rawsonville Woods versus Roberts.
Hello, you're on Sandra Kuzi on behalf of Rawsonville Woods.
Thank you. Today is the day and time set for hearing on plans request to lift the Sarah stay. That stay's been in place for 118 days. This case was scheduled at 1 o'clock. It is now 1:56 by the court's clock. Defendant has failed to appear. Ma'am, how do you wish to proceed?
We have wish to proceed with the judgment of possession only. The rent to retain is $4,685.35, cost of $164 for a total amount of $4,849.35.
Defendant having failed to appear, the Sarah stay is lifted. Default judgment shall enter in favor of plaintiff and against defendant with total judgment $4,849.35. Anything else in this matter, ma'am?
No, Your Honor.
Thank you. This is 224296 LT. This is Evergreen Town and Country versus Nicole Durkin and Ryan Broughton. Today was the day and time set for hearing on plans request to lift the Sarah stay. Case was scheduled at 1 o'clock, is now 1:57 PM by this court's clock. Neither Mr. Robinson nor either defendant have appeared in this matter. Plans request is denied. This is 224567 LT. This is Country Meadows. She didn't come back. Versus Ashley Rife Snyder.
Sandra Kuzi on
Ms.
behalf.
Hosey?
Yep. We
Sorry.
at this moment, we do just request an adjournment for, I believe there's a date that's available, the 11th. You just request to have this matter adjourned.
No, ma'am, I'll take your terms. I thought you had a consent judgment with her
Yes.
and you called and asked her to come back.
We couldn't get a hold of her, so we do request an adjournment at the next hearing. We did enter into a consent judgment during the breakout room.
This matter will be adjourned to January 11, 2023 at 10 a.m. This is 224577 LT. This is Country Meadows versus Melissa Ziegler and Theodore Watson.
Sandra Kuzi on behalf of Country Meadow.
Today was the day and time set for hearing on plans requested with the Sarah stay. That stay has been in place now for 83 days. Melissa Ziegler Theodore Watson. Defendants having failed to appear for hearing on this matter, ma'am, how would you like to proceed?
To request a judgment possession only, for the rent to retain is $5,175.35, cost of $212, for a total amount of $5,387.35.
Matter having been scheduled at 1 o'clock, it's 1:59 by the court's clock. Defendants have failed to appear. The Sarah stay is lifted. Default judgment shall enter in favor of plaintiff and against defendant with rent to retain possession, $5,175.35, $212 in court costs for a total judgment of $5,387.35. Plaintiff's office to submit that judgment for entry. This is 224657 LT. This is Mary Ann. We gotta go back and fix that. I have to go back and fix that. 4647. This is 224647 LT. This is Rawsonville Woods versus Cynthia Gates.
Sandra Guzzi on behalf of plaintiff.
Thank you, ma'am. Today is the day and time set for hearing on this matter. Plans request to lift the Sarah stay that's now been in place for 76 days. Case was scheduled for 1 o'clock. It's now 2:01 by the court's clock. Ms. Gates has failed to appear, ma'am. How would you like to proceed?
We do request a judgment possession only, for the rent to retain is $8,109.04, cost of $164, for a total amount of $8,273.04.
Defendant having failed to appear for hearing as directed by this court, the Sarah stay is lifted. Default judgment shall enter in favor of plaintiff and against defendant with rent to retain possession, $8,109.04, $164 in court costs for a total judgment of $8,273.04. Plaintiff's office to submit that judgment for entry. This is 224799 LT. This is Huron Estates versus Chatale Odom.
Assumption Hart on behalf of Huron Estates, Your Honor.
Thank you, Ms. Hart. Today is the day and time set for hearing on plans requested with the Sarah stay has been in place for 76 days. The case was scheduled at 1 o'clock. It's now 2:02 PM by the court's clock. Defendant having failed to appear, how would you like to proceed?
Your Honor, we'd ask for default judgment to enter against Mr. Odom or Ms. Odom. Rent to retain possession, $3,496.40. Court cost amount of $164.57 for a total redemptive amount of $3,660.97. Writ to issue after January 13th, Your Honor.
Thank you, ma'am. Defendant having failed to appear as directed by this court, the Sarah stay is hereby lifted. Default judgment shall enter in favor of plaintiff and against defendant with rent to retain possession of $3,497.40, $164.57 in court cost, total judgment $3,660.97. Plaintiff's office to submit that judgment for entry. Anything else this afternoon, Ms. Hart?
Nothing additional for us, Your Honor. I believe that concludes it for us. Happy New Year.
Happy New Year, ma'am. Have a good afternoon.
You as well.
Happy New Year.
Thank you. Have a good
Thank
day,
you.
sir.
Bye-bye.
Bye-bye. Mary Ann,
Judge.
2:03.
Not
That
bad,
concludes
huh?
this court's docket. We stand adjourned.